and I've received extensive briefing regarding sentencing. I've received the state's sentence memorandum and the pre-sentence report, as well as the defense sentencing memorandum. And attached to defense sentencing memorandum are many, many letters from family members and good friends, of Mr. Chambers. I don't recall any case in 16 years as a judge with more letters from supporters of a defendant. And then just today I received from the state, I believe, from the Victim Assistance Unit, some photographs of Mr. Hood and letters from family members and extensive letters from Mrs. Hood, Brenda Hood, who I know was here every single day of the trial, and I'm sure that that was very difficult for you.
Your Honor, at some point, Miss Brenda Hood, as well as a very close friend of Travis Hood, Miss Jody Davis, would like at some point to address that.
Okay. All right, and so does the state wish to make, I have a motion for an exceptional sentence below the standard range by defense. I think the state should state its recommendation for the record, and then I'll hear from Mr. Goldsmith on that.
Okay, and if I would maybe be allowed to respond to the motion for an exceptional sentence, I might just do it while I'm making my recommendation.
Okay, however you wish to.
Okay. Your Honor, as you know, and I've already articulated in this hearing, that the defendant was found guilty of manslaughter in the first degree. And he was also found by special verdict that he was armed with a firearm at the time of the commission of this offense. The penalties for manslaughter in the first degree are, as the court knows, based on the defendant's criminal history. And the defendant has criminal history. The large part of the defense in this case, indeed all of the evidence regarding his criminal history was brought out by the defense, that he in fact spent from 1966 to 1989 in various prisons, most of them in California, most of them in high security prisons, and some in federal prisons in various states. Those crimes include robbery, assault, and extortion. It's actually several convictions for robbery. However, at the time of this trial, at the time the defendant committed this crime, either these crimes wash because of the comparability of those statutes to Washington statutes at the time the crimes were committed, or were just Class C or Class B felonies that wash. So that means for his sentence for this crime, although he does have prior convictions, his offender score is 0. This means that on a manslaughter in the first degree, he's looking at 78 to 102 months in custody, and the firearm enhancement adds a mandatory 60 months in custody. That must be served consecutively to the underlying sentence and is not subject to any discretion on the part of the court. It's a mandatory assessment that must be imposed. And it is also not subject to any kind of good time. The state is asking for a sentence of the high end of the standard range, 102 months in custody, as well as, of course, the 60 months of confinement. We're asking for a total sentence of 162 months. The reason we're asking for this is because of the nature of the offense. Manslaughter in the first degree can be committed in any time a person recklessly causes the death of another person. In this particular instance, the defendant very recklessly fired a .45 caliber handgun at the victim of this case, Mr. Michael Travis Hood. He repeatedly fired, which is a reason why the high end of the standard range is appropriate. He fired 3 shots at Travis. The first shot, although testimony in the case was that you can never tell exactly which shot came first, it's very likely that the first shot was not a fatal shot. It was a shot through his torso and in his arm, which was completely consistent with the way Jonathan Voss and even the defendant said that Travis was standing at the time he was fired. So if the defendant had stopped at 1 shot, Michael Travis Hood would be here today. He didn't stop. He continued to fire and then fire again. He fired 3 shots. The 2 shots in the back were fatal shots. One of them lacerated Travis's liver. Another hit a very major artery up in his neck. He basically bled to death. The defendant has claimed that he shot Travis in self-defense, and the jury was instructed on self-defense, and the jury heard argument regarding self-defense. The jury was told that the state has the burden to prove the lack of self-defense beyond a reasonable doubt. The jury rejected the self-defense argument, rejected that the defendant acted in self-defense, and found that he recklessly caused the death of Michael Travis Hood. The defendant's actions in this case were extremely reckless in many ways. The ones that I'd like to articulate and did articulate in our sentencing memo is the first reckless thing that he did, and this is true whether you believe, whether this court believes or does not believe the defendant's version of events. If the court, whatever the court believes regarding whether Travis and Jonathan came up to the defendant's car, called him racial slurs, opened the door, pounded on it, the defendant's subsequent actions were still extremely reckless. The first thing he did is that he retrieved his handgun from underneath the seat of the car. A loaded handgun that he, a convicted felon, was not allowed to possess, and yet did possess for over 20 years. The gun was purchased for him by his wife, and he testified that he always kept it either on him or near him. And on that particular night, he testified that he kept it under the seat, the passenger seat of his car. The next thing that he did is that he followed Travis and Jonathan up the street, in spite of, even if the court accepts the defendant's version of events, which the state disputes. I'm not asking the court to accept the version. I'm simply saying that even if you do, the defendant's next actions were extremely reckless. He followed him when he had so many other options ahead of him, so many. He could have run back into the feedback and yelled, "Help, help, someone's trying to get into my car." He could have run 10 feet into the Beverage Place pub and said the same thing. He could have stayed in his car, called on his cell phone, tried to get help. He could have just jumped out of the car and run down the street in the opposite direction. He didn't do any of those things. What he did was he got out of his car and followed Travis as Travis walked away from him up the street. Now, the law certainly doesn't require a person, when he is being attacked, to retreat. There's no duty to retreat. But what happened in this case, even under the defendant's version of events, is that he acted recklessly when he followed Travis to confront him for whatever reason it might have been. And then, of course, as I've already said, his actions were extremely reckless. He shot Travis repeatedly. I've already talked about that, about how the first shot probably wouldn't have killed him, but the other 2 did. If he had just stopped shooting, things would have been so different in this case. And of course, he did all of this while he was extremely drunk. He had been drinking for hours that day and was highly intoxicated at the time of the incident. And being drunk in itself, although it's certainly not a wise thing to do to get that drunk, that would not in itself necessarily be reckless. But what happens when a person is intoxicated is that intoxication can lead to extremely reckless behavior. And the defendant's reckless behavior resulted in the death of Michael Travis Hood. That's why we're asking for high end. This is not, as you compare this to other reckless cases, other manslaughter cases, the defendant's actions in this case were highly, highly reckless. Whenever a person points a loaded firearm at another, that is reckless. When he then shoots that firearm, that is even more reckless. And when he repeatedly shoots the firearm, that is reckless in the extreme and deserves punishment that is consistent with that recklessness. I think I'll just go ahead and argue on the exceptional sentence now, Your Honor, but if I could have leave if the defense brings up something that I might need to comment on.
Yes.
The defense has, as you know, asked for an exceptional sentence, and basically what they're asking the court to do is to impose no sentence at all for the crime of manslaughter in the first degree. They're asking you to completely ignore that the defendant is looking at 78 to 102 months and simply impose what the court has no discretion discretion it must impose, which is the 60-month firearm enhancement. This would be an extreme miscarriage of justice. The defense is claiming that this is a failed self-defense case. And under 994A, 535, section 1, paragraph A, the court does have discretion to impose an exceptional sentence when the court determines that to a significant degree the victim was an initiator, a willing participant, aggressor, or provoker of the incident. He's claiming that Travis was the aggressor, that Travis provoked the incident, and that the defendant, all he was doing was merely reacting. Well, in making this argument, what the defense is completely ignoring is the defendant's own actions in this case, as I've already articulated. That he followed Travis with a gun, that he shot at Travis. That Travis was immediately incapacitated. If you recall, Dr. Lupin testified that the shot through the torso and the arm would have immediately incapacitated his arm. There was no testimony in this case that Travis swung the shovel before he was shot. This case is not like the kinds of cases where the court has considered an exceptional sentence downward. The cases that are cited by the defense, they're very different from the case that you have before you, Your Honor. First off, the evidence in those cases was not disputed. In this case, it was up to the jury to decide what happened. The evidence was completely disputed regarding whether the defendant's version of events or Jonathan Boss's version of events was true. In both Burnell and Pascal, cited by the defense, there was undisputed evidence. And in both of those cases, the parties, the defendant and the victim, were in a long-standing, troubled relationship where the victim had, in Pascal particularly, the victim had for many years abused the defendant. The victim was the boyfriend, the defendant was the girlfriend. In the incident that caused where the defendant, Pascal, ended up stabbing Kiefer, the victim, they were in the middle of basically a knockdown, drag-out fight. He had pushed her, he had knocked her down in front of their child. He had then she had gone and gotten a knife. Another altercation ensued, and Kiefer actually go to her, said, "Come on, just do it," and she stabbed him. That's not what happened in this case at all. The parties didn't know each other. Depending on, even if you accept the defendant's version of events, Travis would walk away from the defendant. He was not an active participant in a fight that caused his own death. And then in State versus Burnell, I think it's important to note in Burnell that the trial court imposed an exceptional sentence, but the reviewing court, Division 3, actually didn't get to the issue of whether the exceptional sentence was appropriate or not, because it reversed it on other grounds, and specifically declined to rule on the propriety of whether the court should have granted an exceptional sentence. But the facts of Burnell are entirely different from the facts here too. Similar to Pascal, it's a knockdown, drag-out fight between a husband and wife. The wife got a knife, attacked the husband. They struggled for the knife, and then he repeatedly stabbed her. No doubt about it, the jury found him guilty of murder because he overdid it, but they were in a complete struggle based on the long-standing problems that they had. And then Burnell called the police and sat there sobbing, waiting for them to come and help her. That's not what happened in this case. The defendant put his gun back in his belt, walked down the street right past witnesses, got into his car, sat there for a moment or two, and then drove off, following in the same direction that Jonathan Boss had taken Travis Hood, trying to get help. So if you compare Pascal and Burnell to the facts of this case, an exceptional sentence is just not appropriate in this case, Your Honor. The defense also argues that because the defendant has not been convicted of any crimes since 1989, and because of his age, a sentence within the standard range plus the 60 months firearm enhancement would be overly harsh. Although they don't outright say so, they are asking the court to find an exceptional sentence based on the defendant's age and the fact that, as far as we know, for the last 20 years, he's been a productive member of the community. The court cannot do that. State versus Freitag is the main seminal case on that issue. A court may not base an exceptional sentence upon the personal circumstances of a defendant, such as their age, such as their whether they're upstanding in the community. That is an inappropriate basis for an exceptional sentence, and that's because it's the legislature that determines what sentences are to be imposed for a crime that is committed, and to look at a defendant's particular personal circumstances and determine that he shouldn't get the sentence that has been imposed by the legislature actually overrides the legislature's authority in setting sentences. There's a statute that I know the court is aware of, 994A 340, that says the sentencing guidelines and prosecuting standards apply equally to offenders in all parts of the state without discrimination as to any element that does not relate to the crime or the previous record of the defendant. If that were not the case, then courts could fashion their own sentences at any time, and the SRA would really have no meaning. This court might be sympathetic to the defendant. You heard all the evidence in this case. You know that it was a complicated case in terms of what happened that night. If the defendant had just acted differently and not gone after Travis, things would just be so different today. I know that the defense says that an exceptional sentence is appropriate, or even a 5-year sentence on 60 months that has to be imposed under the mandatory firearm enhancement is exceptionally harsh because the defendant is old and because he will have precious few good years left when he gets out, even if he is sentenced to nearly 5 years. I would like to put on the record that Travis Hood was 35 years old when he was killed, when the defendant took his life. Using the same article that was attached to the defense memo regarding life expectancies, he would have a life expectancy probably of around 75 years. His life was cut short by 40 years. He has no good years left. The defendant took all of those away from him. And he died a painful death. He died in front of his best friend, or at least extremely good friend, who could not save him, could not help him. And he had friends. He has a mother. He has a child. His mother and his friends sat here in court day after day and had to endure the defense trying to turn Travis into a racist, violent person. An exceptional sentence is not appropriate in this case. Of course, this court has discretion within the standard ranges, but an exceptional sentence would not be appropriate. The state is asking that the court deny the request for an exceptional sentence and impose a sentence of 102 months on the underlying crime and 60 months for the firearm enhancement. I know that Ms. Brenda Hood, who submitted a letter, as well as Jody Davis, would like to speak to the court. I don't know whether you want to do that now, Your Honor, or at some other point. I, of course, will defer to you.
Let's go ahead and do it now.
Okay, would you like to come forward? Come a little closer so I can hear you.
Good afternoon, Mrs. Hood.
I want to read the letter from his daughter, Destin Williams. My dad was killed 2 years ago, and I can't forget or let it go. It's been really hard for me. I was only 12 years old, and I'm almost 14. I understand what went on more. I find myself crying a lot lately. I stopped talking to my family. I hold a lot in because it's hard to talk about it. I have to go to counseling at school because I broke down in my class. Counselors trying to help me become happy again and get me out of depression. I miss my dad with all my heart. I dream about him a lot. I wake up crying. My world was taken away, and it doesn't seem like anyone cares. I know a lot of kids whose parents have been taken from them. It's really hard, especially when I think of the fact I won't ever see my dad again, and everyone tells me he's in my heart. But that's not the same as him being here. I don't know how someone could be so heartless to take away my daddy. He won't get to walk me down the aisle to see his little girl get married. He will not get to meet my children or grandchildren. I ask myself why a lot. I miss my daddy more than words can describe. I'd do anything just to be able to see him one more time. I love him with all my heart, and my heart was taken. It's really hard for me to get close to people because there's a fear they'll be taken away. Thanks for all your help. Rest in paradise, Daddy. I love you, from his daughter, Destiny Williams. I'd like to say that I paid my ticket to Seattle because there was no funding for buying a ticket for me on both occasions that I was here. And I have acquired financial burdens upon the shooting of my son and upon his death. Hospital was $66,876. Funeral was $7,340. The headstone was $2,355. I already own the burial plot. I am not paranoid, don't fear for my safety, and I'm not afraid to die. I am right with God. While Travis won't be back in this world, I would like to seek justice for him. By all definitions, I also have post-traumatic stress syndrome and would have no problem getting a diagnosis for it. But that's my misfortune. Society's not going to have sympathy for that. Travis always said he was the last of the Mohegans. I had that put on the back of his headstone. I'd like to say the defendant showed no remorse through the whole trial. The defendant was very arrogant, even turned his nose up at me and Jody several times. The defendant didn't even show any sadness that the shooting had taken place. The defendant walked 195 feet away from his car to the truck that Travis was getting into, supposedly to get better light. He clearly wasn't scared. He had a gun and intended to use it. In court, I mouthed out Michael Hood's mom. The defendant twisted that into murderer. Although that's not what I said, I do think the defendant is a murderer. I won't forgive you. I hope you die in jail and rot in hell. Only God can forgive you. I will leave justice to the judge and the courts. Thank you.
This is Jody Davis.
Okay, very good. And good afternoon.
Good afternoon to you.
And you're Travis's sister?
So I was like his sister.
Okay.
He was like brother to me. He's like an uncle to my children. They're both here today. First of all, I wanted to show a picture of Travis. There's 6 people in this picture, and this is of him leaving Jacksonville to come here to Seattle. And there's one white person in that picture, and that's Travis.
And I think that's the same.
Yes, ma'am. And that was on 9/3/2011, 4 months before he was murdered here in Seattle. This was him at Jimi Hendrix's grave. He was one of his favorite singers. First thing he wanted to see when he was in Seattle. We have lost a lot with losing Travis. He has taken so much from us. I thought Travis would be great here. You know, he was doing good. Mr. Chambers also had a great day that day. They both had a great day. I don't know what happened. I know Travis. I know Travis did not say what Mr. Chambers said he said. I don't know what he said or what was misconducted. But these are all my niggas. I don't care how it's portrayed up here, but we're all just friends. It's just a word. My 7-year-old son is sitting in the courtroom now, asked if after this day was over, if his Uncle Travis is coming back. No, his Uncle Travis is not coming back. We will never get to speak to Travis again. Never get to see him again. And I hope you give him the maximum sentence, because I think he deserves everything he gets. I will never forgive him, and I will never forget the day of January 21st.